Hi, my name is Patrick Maestas, and today I'll be talking about tort liability here for EDL 850, which is Mod 13. Let me figure this out here. Okay, there we go. What is tort liability? Yeah, it's based on the idea that individuals are responsible for the consequences of their actions, or sometimes for lack of action. And this might result in an injury or death, okay? And we are talking about right now we're talking about schools, but tort liability or tort law could be anywhere. It could be at a restaurant, could be at a shopping center, it could be at Disneyland. But we are talking about, public schools or even places of higher education. Usually there's two types of tort. There's intentional and unintentional tort, okay? Intentional is the intent to harm. It's deliberate act, okay? The unintentional is, like it says, it's not on purpose. It's usually due to negligence. And most of the cases I'm going to talk about are due to negligence. Moving on to the next one. Tort case number 1 is Motley versus Portland Public School District. In 1987, Chrisetta Mosley got into an altercation during her lunch hour with a girl named Wanda Griffin. Apparently the fight was in the hallway, and during the fight, she took out a knife and stabbed Chrisetta in the face and the chest, and she had permanent scarring. There were security guards at the school, but they were not in the hallway when the altercation occurred. The Portland School District, they actually won this one, okay? The plaintiff does not always win. It's something I learned today, the past couple of days. They won their case, according to what I read, that the plaintiff failed to support the claim of negligence. Okay, the school had reasonable measures, so they were not liable for the injury to Chrisetta Mosley. According to the case, there were security guards there, but there weren't any in the hallway. But the fact that the school had some kind of security measure, that makes them not liable for injury. Okay. Moving on to tort case number 2. This one is kind of sad. It's with Brahacek versus Millard School District. This is back in 1979. The plaintiff is Darlene Brahacek, and she brought a wrongful death lawsuit against the Millard School District because her son died in a PE class. It was raining, they were indoors, and at the time, from what I read, golf was a mandatory course. They don't have those anymore, at least not where I went to school. Anyways, they were indoors and they were practicing golf swings. And from what I read, there were some instructors around. Like I said, they were inside. And David was up against the wall or up against the bleachers, and some girl was swinging her golf club. Sometime in that moment, David walked close enough to get hit by the golf club. Okay, he was knocked out unconscious, and he died 2 days later. He never regained consciousness, which is kind of sad for all parties involved, not just for the parents. According to my notes, the school district was found negligent for lack of supervision. Okay, they needed to exercise proper supervision. The school district made a counter case that David it was partially his fault because even though he was standing against the wall or against he was standing far away, he walked up close enough to get hit. From what I remember in my readings, the school, they should have been watching him. He had no idea he had never played golf before, from what I read, or maybe did not understand the rules. And so the school was negligent, and they awarded the mother, don't know what she was awarded, but she won her case. Tort case number 3 is Davis versus Monroe County Board of Education. Aurelia Davis sued the Monroe County Board of Education on behalf of her 5th grade daughter, LaShonda. She was suffering sexual harassment at the hands of another student. Okay. The mother, Aurelia Davis, she claimed that the school's complacency created an abusive environment that deprived her daughter of the educational benefits accorded to her under Title IX. On appeal from successive adverse rulings in both district and appellate court, The Supreme Court granted Davis certiorari, which is basically Davis won the case. Okay. Title IX states that all citizens need to have equal access to education. Harassment, if someone's being harassed, it prevents that access to education. Okay. And those educational opportunities. Title IX also, they have prohibitions and they're very, very clear. You have to comply by Title IX obligations, or you could face legal action, which is what happened here. And also, what I wanted to say, I should have said earlier, the school board, they ignored the mother. The mother told the school board many times that her daughter is being abused. They just ignored her, and so her Title IX rights are being taken away. And the court, not the court, I'm sorry, what I think, this is total indifference. This is negligence also, as well. They neglected to take care of her. And because of that, she won her case. Tort number 4. NM does not stand for New Mexico. NM is just an acronym or initials in order to, from what I read, to protect the family and the child. I think if I would have dug deeper, or maybe the professor could dig deeper, maybe you know already, my apologies. You probably know who it is, but this one's also, they're all sad, but this one is also kind of hard to read. So it's a child, an elementary school child and his family versus the Anchorage School District. So this child was at Rogers Park Elementary, and he was he was on campus at the school, running to his mother. He had like some things to give to his mom. He slipped and fell into some pine shrubs. This happens every day. My daughter falls down every day. But what happened here was when he fell into the pine shrubs, he fell face first. And as you can see in the picture, it's probably not a big deal, but when you're 5 and you fall face first, it's pretty bad. And from what I read here, the sticks, they penetrated an eye socket, jabbing him and then going all the way to the frontal lobe of his brain. It spared the eye, I think, or maybe it did hit the eye, but it went all the way to the back of the brain. The kid went through surgery, and he did suffer immensely afterwards. It's a difficult read as a father, but he suffered a lot, and he's still suffering. But my apologies. Let me continue. The school district was sued for negligence because they allowed the shrubs to remain. As you can see in the picture, they left them there without taking them out. And that's a very heavily trafficked path. And they probably didn't think about it, but as we can see, someone was affected. A child was affected. They were awarded $14.5 million because the school was negligent. They left the exposed stumps on the ground. And I didn't mention it here, but I kept reading that the school district, and probably many school districts, they actually set aside a fund for lawsuits, because these happen a lot, and which was really interesting for me. And I think maybe that's something I should look into. Moving on to tort number 5. The last one is Day versus the Ouachita Parish School Board. Defendant Morgan Day hurt his back lifting weights and playing football. And he was ordered by the doctor not to lift weights and not to play football for a week. He had something wrong with his back. Okay. So he went in the following week and he was just watching, football players, they go and observe, they want to be with their team. And an assistant coach came by and asked him to do a deadlift. And I apologize, my notes don't have what kind of exercise he did, but he did an upper body strength exercise, and the assistant coach told him that he had to do it. Morgan Day told him that he has a doctor's note, his lower back is hurt, he's not supposed to lift weights, and he's not supposed to do anything like that. But the assistant coach said, no, you'll be fine, just do it. Basically told him he had to do it. He did it, he injured himself. He went back, his back is really screwed up. He couldn't play football, he couldn't play baseball. He lost interest in sports. Morgan Day, the student, dropped out of high school or had to withdraw because he had missed so many classes due to his issues with his health, and he had to enroll in an alternative school. So the mom sued the school board and she sued the assistant coach. And the trial court found the defendants liable for the injury. From what I remember, medical expenses were about $7,500. They got awarded about $150,000 plus $30,000 for future medical expenses, and another $50,000, which off the top of my head I don't remember. And I think it'd be a bad video to start Googling stuff right now or just going through my other notes. But this is an obvious case of negligence by the assistant coach. Somebody has a sick note, you're hurt, don't make him lift weights. you just cost the school board millions of dollars. But more importantly, Morgan Day lost his interest in sports. Probably lost, I don't know what, maybe he's not, I have no idea what happened to him. But you ruined the child's life by being negligent. Okay? So, in conclusion, one of the questions you asked was, if this happened in my school, what would the reaction be? I work in higher ed. I don't want to hide behind the I work at higher ed because I think I've done it too often. If I were to work in a public school, with all the stuff that's going on, especially with the football one here, if I was the football coach, I'd probably be fired, and maybe during the trial still be teaching or maybe even suspended with pay, but I would probably be fired. In regards to all the other activities, they're all different. The high school one, the kid's young man, and then we're talking another case where the young child was 4 or 5 years old and he got permanent brain damage. They're all different situations, and so their reactive measures in regards to what happened to me. Again, I'm going to go with this example here. I could probably lose my job. If something were to happen like that at Auburn University, as it is, they're considered adults, even though in loco parentis does cover universities, 18-year-olds are considered adults. As a matter of fact, when you play football, you sign a waiver. If you're a football player for Auburn, there's a risk. So you get hurt playing football for Auburn, there's a risk involved. The coaches are protected. If you're not a football player but you play basketball, you sign a waiver. You're not going to sue if you get hurt because you're 18 years old. So again, it is different. I don't want to say I'm hiding behind Auburn University or higher ed, but it is a bit different. And since I don't work in public schools, I could only guess about what would happen. What proactive measures could have been done? In regards to Morgan Day, his example, I think he had a doctor's note. It was up on the wall. Coaches saw it. Why did the assistant coach make him do it? I think the coach should have made an effort. Maybe told the other coaches that they should have done a better job with. Not better. They could have told the other. My apologies. The coach could have done a better job in relaying the information to the other coaches. He could have saved Morgan. Could have saved his career, his grades, and his future. I work in higher ed. It's a different situation, different questions here. Professional ethics. Again, here in higher ed, it's a different situation. But if I were to work at a high school as a football coach, you got to make sure all the coaches are in line with, honestly, tort law. You got to be aware of the limits of what they can and cannot do, especially if you're a coach for a football team or basketball team or any sports team. You got to be aware of injuries, and you got to protect the kids. First of all, you got to protect the kids and be aware that injuries and injuries due to negligence will fall upon them. Thank you so much.